This is Paul. Yes. Um, I just got to the study room, yeah, and I had went through some of the forms on the Washington State Court website yesterday. Yeah, it is. Well, let's see what time it is here. It's not working very good. Well, maybe Judge Porter remembers this, the MP 270, RCW 1077.084. I was looking at the state court forms last night. The form that was used by the city doesn't seem to look like the forms on the court's website. Now, I just thought we would start with some forms because you've been using some of these court forms in ways that I don't think that they were actually designed. Yes. In fact, it could be that you've been changing them, yeah, because you just didn't like how the court administration had designed them. Now, last night I was expecting to get a phone call from my sons in Maryland. Yes. But nobody's called me and I haven't gotten any emails. And I had thought about some lawsuits of what happens if a court decides to change the actual forms that are necessary for the order dismissing misdemeanor charges. Now, there was an agreement by the parties because of the individual, yes, that had done the mental health evaluation when I was in jail for 27 days. Yes. Where I had responded, just give me the notice of the court hearing and I will appear in court. Now, at that time, I was scheduled for a court hearing on September 27th of 2016. Yes. And I had been arraigned on the 5th of January of 2016. Yes. For the allegation of violating a no contact order. Do you remember this? Yes. Kind of a top secret signature of myself. Now, there was an accidental email that I sent at 4:48 p.m. from this library. Yes. Where I had said, give me every IP address in the world. Yes. Now, I wasn't in Sequim at 7:47 a.m. And I was not in Port Angeles. I was not in Sequim, Washington at 4:48 p.m. Yes. But somebody had handed Judge Rohrer an email after they had filed the traffic citation. And I thought that any time that you allege a crime, the evidence, yes, that was used to have me arrested, the probable cause arrest that I had committed the criminal non-traffic violations, that evidence should have been included. Now, it was actually an allegation that I was in Sequim, Washington on December 31st, 2015. Yeah. Now, you added this in. Do not use email to communicate with Heidi Budnick or any other protected party. And I actually didn't communicate with her, though it says I did. Earlier that day, the King County Administrator, yes, had obstructed every email from my Gmail accounts. Yes. But I was arraigned, and the arraignment date was January 5th of 2016, and then I had a speedy trial. And then I had not waived my right to a speedy trial. Yes. In fact, I had sent an email to my public defender, Bruce Hanafy, yeah, that I wanted it explained to me what the speedy trial was. Yes. Now, what is very important is that he did review the file from the Clallam County case and cause number. Yes. And it appeared that the service of the temporary protection order entered in the cause number was never served upon Mr. Budnick. It appears that 2 attempts to serve Mr. Budnick were made by law enforcement. Both of them were unsuccessful. Now, the permanent order of protection is not silent as to service. As he had said, there were 2 attempts to serve me, and I was not served. Otherwise, it would have said that he was served. Yes, but he made up some bullshit again. Now, he certified under the penalty of perjury of the laws of the state of Washington, yeah, that the foregoing is true and correct, and for my public defender, yes, to have attached true and correct copies of the permanent protection order entered on July 31st of 2015, yes, and then the notice of service that was served on me in the Sequim Public Library so that every library. Now, I'm wanting to sue today, okay? Okay. Now, obviously, the permanent protection order is not silent because he said in bullet point 2 that I was not served. Now, I know there are a lot of judges that dislike the idea of me suing them, but I'm wanting to do that. Now, I put a lot of these time to sell hearings in here. Yes. And just looking at some of these court forms, I know they're in here someplace. Yes. A lot of screenshots here. In fact, I started a new folder for screenshots so they wouldn't take up the full. Oh, look at MP282 2510. Yes. I think it's MP270. Wait a second here. Yes. 270, 270, 270, 270. Yeah. Now, this is the order for competent treatment misdemeanor. Yeah. No, that's not the right one. Now, hang on just for a second. I think I have to go back one. Yeah. I just wanted to look at, because it said it was 6 pages, and I was only served 4 pages. Now, maybe I have the wrong form here. Yes. MP270, MP420470. MP 1.0.17024. I'm going to have to go back to the Washington State Court side. It just is the 4 pages. Because maybe I didn't download it. I thought I did. Yes. See, the MP250, 1.07 competency restoration. It looks similar, but it's not the right one. Hang on. Order for competency restoration treatment misdemeanor. Oh, that's what I'm going to the cell hearing on January 4th. Now, we can talk about this one until I get the other one. Yes. Now, based upon the evidence presented by the parties and other relevant records in the case, just so I know, is this a possible probable cause type of case instead of criminal non-traffic? Now, just reading this court rules, yes, I would have thought that Judge Landis or the magistrate would have been presented. Yeah. Now, competency to stand trial by a preponderance of the evidence that, as a result of mental disease or defect, the defendant lacks the capacity to understand the nature of the proceedings against him or herself. Yes. Now, this one says the same thing, but this is for the unsuccessful. Yes. Unlikely to be successful. Yes. I'm going to have to go back to the court website and get a copy of the MP270. Pope. Now, you're saying that I am not competent? True. Well, the procedural nature of the referral defendant. Yeah. Competency to stand trial, extent of the charges. Competency restoration treatment should be provided. Is this what you're going to use with the cell hearing on January 4th? Now, since it's the 2-count serious crime per se of violating the protection order, yes, and the cyber stalking, yeah. If I go back to the original form, because I think this is the form that you're wanting Judge Landis to sign when we go to the cell hearing. I just want to look again because I included what's it called? Yeah, it's the court rules. I never got one of these signed by any citizen right now. Now, should the hearing have been probable cause instead of criminal non-traffic? Oh. And then the complainant understand that I have the choice of complaining process under rather than signing this affidavit. Now, does that go for both citizens and those in law enforcement? Because I would think an officer that actually investigated it, yes, would have had their own form that they use, kind of like a domestic violence police report and an actual description of exactly what happened. Then some pictures of how the individual was abused or victimized. And then there could have been some sworn statements from other witnesses. Now, since it couldn't have been a law enforcement because